Welcome, everyone. Thank you for joining Darien Library this Wednesday evening for If There's a Will, There's a Way with Mark Chioffi. Mark is the managing member of Chioffi Law, LLC, which has offices in Westport. He practices in the areas of estate planning, including succession planning for closely held business owners, estate and trust administration, and probate litigation. So I feel like we're in good hands tonight. Mark is also a co-chair of the probate and estate section of Fairfield County Bar Association. So tonight's program is part of a series, Begin with the End in Mind. The end is not a topic many people feel comfortable discussing, and that's why we're not often prepared for, when that time comes. So I'm excited for Mark to be here with us tonight in the beginning of our series. And if you're interested in learning more, please join us the first Wednesday of every month starting at 7 p.m. July, we're going to take a little break because I'm sure everyone will be doing more exciting things, but look for the next program June's next. I'm off with my months. So June, and then we'll take a break in July. Before we begin, I'd like to mention that programs at Darien Library are made possible by the annual Friends of the Library campaign. We thank you for your support to make programs like this, as well as our collections, available to the community. And now I'm going to pass the mic over to Mark. Thank you.
Thanks so much, Amanda. I really appreciate it. And welcome, everybody. Thanks for taking time during a busy week to talk about estate planning. I really appreciate it. I've been doing this area of the law for many years, and I've seen what can go right and what can go wrong. And really the hope tonight is that by going over to the process together, we can try to make sure that things go more smoothly for you and your family. And I'll try to demystify some of the terms and some of the things that people worry about when they talk about putting together an estate plan. So why don't we just get started and take it from the beginning. So the idea of what an estate plan is not the easiest thing to answer, because it can really mean many things to different people. There's no right or wrong answer to it. But from my standpoint, when I meet with clients to go over an estate plan, these are the things that I'm trying to cover with the work that we're doing for them. So making sure that you can take care of yourself and your family during your lifetime if you become incapacitated. So even before you start talking about wills, the idea of making sure you take care of yourself. As part of that, a really important component is the ability to make healthcare decisions in the event that you're not able to. It's a very formal area, and you want to make sure that you have the right documents in place to make sure that the important decision-making can be made by somebody that you trust. And then the more traditional idea of making sure that you can transfer your property at death the way you want it to, hopefully in a tax-efficient manner and with the right people in charge of everything. And as part of that, you would really hope that you can avoid probate costs and administrative costs and do it as efficiently as possible. And I think with proper planning, you can take steps to kind of make it go smoothly and to make it go in an efficient way. So think of this whole thing as trying to be almost like you're putting together an instruction manual or a love letter for your family, so that you can tell everybody what your wishes are, how to do it, and who's supposed to do it, so that at the end of the process, it's spelled out, and all your family has to do is follow your wishes and follow the documents and take care of everything, hopefully in an efficient way. We really don't want to have tension, confusion, stress. Losing a family member is really tough enough all by itself. And to have to layer on top of that the idea of dealing with an estate administration, we really our goal is to try to do it in a way that's mindful of what everybody is going through at the time, and trying to be sensitive to the feelings and the priorities and the different emotions and the different factions within a family and all of the stuff that we all have to deal with our own family. So we're really trying to be very sensitive to that process when we're going through an administration within a state. At the end of the day, for the most part, you're not really going to know how good your estate plan is, but your family will. And so really try to do what you can to make it as smooth for everybody. When I meet with new clients, or I'm at a social gathering or a networking event and people find out that I'm an estate planning attorney, I usually kind of come across these three types of solutions to the problem, and I'll put solutions in quotes because I think none of these are really the best way to approach an estate plan. So one is just the ostrich approach. I don't really want to think about this. I've got other things to worry about. Let the state decide. I'm not going to bother with a will or doing anything. I'm sure my family can work it out. And of course, that's the worst approach that you could take. Not only will it likely be more expensive and drawn out and complicated, but it can really lead to some unintended results. And I guess the most obvious one would be, the idea if you die without a will and you have a spouse and children, no matter how young they are, there's the statutory arrangement that says, the spouse gets a certain amount and then a certain percentage of anything above that amount, but the rest of the estate goes to the children. And so that's usually not what a client thinks is what's best for a family, especially with young children, and the need to worry about guardianship, to hold money, and just maybe not providing sufficient money for the surviving spouse. And, in a few times in my practice, a client has come in after a person's passed, and we've been faced with this, and it's really been, enough for me to know and to hopefully convey effectively to you that it's not something you want to rely on. It really is a tough approach. And even the simplest will is probably going to serve you much better than nothing at all. The second approach is this idea of, well, I don't really need an estate plan. I don't really need a will because I've got it all worked out. My bank accounts are owned jointly with my children, and I've got my brokerage account with a beneficiary attached to it, and my house has got my child's name on it. And so when I die, there's no need for a will because I have everything all set and there'll be nothing left to worry about. And on a certain level, I can understand that maybe with some assets, or maybe in very simple type of situations when a client or a person just has one account or two accounts. But overall, that can more likely lead to problems with planning because there's this juggling of all of these different accounts and assets. And I've had clients come in and they say, well, I added my daughter on my joint account so that she can help me with banking. And that's great, convenient. But when you pass away, that one child is going to get that account, no matter what your will says, by operation of law. And so how are the other kids going to feel if daughter, who was only on there for convenience, ends up with a significant account and the other children are left out? There are ways to try to fix it after the fact, but generally speaking, it's better to have a coordinated overall plan. And if that includes the idea of a beneficiary form or a joint account or something like that, great. But don't just think that you can rely on that and solve all of your issues, because almost every estate that I've seen, there is a need for a will to go through probate. And so it's a lot more work to do that if you don't do proper planning. And then the third thing is I like to call I love you wills, meaning that they're simple, they just care for family members, and there's no regard to things like taxes or trust for kids or anything that might be special that you do with planning. And again, that could work out for some clients, and you could have technically a 2-page will that might be perfectly fine for you. But in the average estate, particularly in Fairfield County, maybe focusing with a little bit more robust planning will serve you well and perhaps be worth the effort to put in place ahead of time. Self-drafted wills, another option, and I guess as the years go by, becoming more and more of an option for people. I personally have not tried out the software. I always say I'm going to, just to see what it's like, because be curious just as an estate planner to see what it looks like. I think in the times where I have seen clients with their own drafted wills, it's turned out that I've had suggestions to make, and even if it's something as simple as providing for what if a person you've named is not alive when you pass away, a contingent or a backup beneficiary, sort of the simple parts of estate planning, at least from our standpoint, might be missed if you're drafting things on your own. So, I guess everyone can make their own decision with that, and I understand the value approach to it, but probably not a bad idea to have a lawyer look over your will no matter what.
Mark, can I interrupt you real quick?
Sure.
The other day I heard someone use the term holographic will. Would that be like an I love you will?
Well, that's an informal will that's not with all the formalities of being in writing with witnesses and all of that. And it could possibly work under some circumstances, but if there's a relatively straightforward process of putting down your thoughts on paper and signing it in front of a couple of witnesses, I would always recommend to a client that you try to do that as the best approach, rather than relying on something that's less formal that may or may not work. It's even if that type of will is ultimately successful, the effort that it would take to kind of convince the court of that would be more than you'd probably want to justify.
Okay, thank you so much.
Yep. So this word probate, it's kind of a loaded word. And I think a lot of people have a negative connotation. And I remember through the years when I was reading newspapers that were delivered, you'd see those Saturday editions or Sunday editions with that bright yellow flyer, come to the Ramada Inn and avoid probate by doing XYZ. And we're going to talk in a bit about revocable trust, which is a technique that minimizes probate court involvement. But I want to put everyone's fears to rest that probate is not necessarily a bad thing here in Connecticut. Especially in Fairfield County, I find the courts to be very helpful. Very friendly. They're low pressure. If you have to go to court, you're usually sitting around the conference room table with the judge rather than having the judge behind a bench. But generally, the idea of what probate is, it's the process of taking things that have your name on it, and through the admission of a will and the appointment of an executor, giving that executor court power to go and handle the administration of those assets on your behalf when you're gone. So there's a formality associated with it, because what would be worse than having a fake will admitted, or a person who's not supposed to be executor or appointed getting access to your account? So there's a formality, and there is a fee that you pay when you go to the probate court. But the way it's set up, the fee is tied to the size of your estate for tax purposes. So in some respects, it doesn't really matter if your will passes everything that you own and you go completely through the probate process, or your will passes nothing that you own and you don't use your will at all and your process is done with trusts and will substitutes. There's going to be one fee paid to the court. So I don't think it's necessarily something that you should work really, really hard to avoid. There might be instances where you take steps to minimize the involvement, because the the probate process is a little bit more formal, as I mentioned, and it's a little bit more public. There's some information that people can see, but sort of, I think for most clients that come through my office and we handle estates, there's going to be some things that pass by will and some things that pass through other ways. And overall, if you have an overall plan that's coordinated and everything works together, meaning that there's not one part of your plan fighting your will or another part of your plan, then it's not a terrible thing to have a probate component to it. When does it make sense to make an estate plan is a question that comes up a lot. And I get it. This is not the most exciting thing to do. No one really likes to spend the time or to spend money putting together an estate plan and reading through legal documents and waking up at night worrying about when they're going to be used and all of that stuff. But it is, in my opinion, one of those things. It's like a sign of being an adult. I always remember when my first daughter was born, getting life insurance policy made me feel like for once I was an adult and I wasn't just thinking about myself, I was thinking about others. And it's the same thing with getting an estate plan in place. It's just one of those things. It's a marker in life that you really should have this stuff worked out ahead of time. And it's best to try to do it when you're healthy and you have time to go through the process and think about it and not be rushed. Those emergency plans, and we get those calls, so-and-so is going away on a trip for the first time without their child. And is there a way we can just name a guardian? So if something happened on the plane, they won't go with my brother or my sister. And, from my standpoint, there really is no quick, simple, throw it together in 10-minute estate plan. It's something that, no matter how big or small an estate is, we have to go through the same process more or less. And we're just not able to offer that to clients. We can do things on an expedited basis when there's circumstances that require it, but really trying to put it together quickly is not something I would strive for. And then the last point is I have a credenza filled with plans that we've started and not quite finished yet. And, I keep all of the matters on my credenza and I think about them and I worry about them and I write to clients to say, when do you want to finish everything? Again, it's not the most interesting thing to work on, but it is a good feeling when you get it behind you. And there's also a flow to it. If I meet with a client and we talk about everything and we say, you need this particular trust and this is why we're doing this document, and I draft and I send it out, and then 5 months later we pick it up and we start talking about it, it's going to be hard to remember why we were setting up this trust in this way, or why things are going with this person in charge versus the other person. And so to kind of keep the thread going and to keep a continuity and just have you feel like you understand the process better, the ideal estate plan in my mind is trying to get it done within a month or two from when you start. And really that first meeting is the heavy lifting from your standpoint, the idea of putting your thoughts down on paper and talking through some of the issues and finding out about how the tax law impacts everything. But by the time we're through that, for the most part, there might be open items that you leave for another day, but you'll probably be more than halfway through the whole process by just having that first meeting. And then reviewing everything takes a little while, but hopefully when you're reviewing the documents, they say what you want them to say. And then getting together to sign is not a difficult thing. It's, could take a half hour or an hour just to physically sign the documents. And there might be some beneficiary forms and other things that you need to clean up as part of the planning. But you'll feel great about getting it done. And it's the hardest thing, I think, for most is just getting it started. This also comes up with clients is, okay, I might have done a plan 5 years ago, 10 years ago, when my son was born, when we first got married, when we bought a house, or even if a plan is done in my office and something we worked on a few years ago, the question is, when does it make sense to go over it? And so there's no exact, you must do it every 32 months, otherwise you're in default. It's really, you stay in touch with your attorney. If there is a change in your family circumstances, meaning birth of a child or maybe a death of an extended parent or a family member, sibling or something like that, and it kind of impacts your planning, maybe you would talk about it. If there's a big event that changes the size of your estate, so we might have gotten together thinking you have an estate of $600,000 or $700,000, and then perhaps there's a big inheritance or a sale of a business, and you have all of a sudden 6 or 7 million or 16 million. That can be significant from a planning standpoint, and there might be doors now opened about gifting to your children or grandchildren or charitable giving or something like that that makes you think of things differently from when you did your original plan. Also, when I started practicing, the estate tax laws were pretty boring and predictable. There was always a rumbling of a change, but they stayed pretty consistent. Maybe the exemption amount would go up every few years, but there wasn't too much that changed. Now, I think we're in an environment where states have gone in their own direction. The federal law seems to be a bouncing ball in terms of proposals. There's been talk just this year about changes to the estate tax laws. So it's always a good idea to have a chat with your attorney when there is a change or a pending change to the estate tax laws, because there might be some planning you can do now that take advantage of something that might not be available next year. So I always encourage clients to talk about that type of planning. And then finally, if you do move out of Connecticut or into Connecticut, most of what your plan is can probably stay in force, but there might be some ancillary documents or revisions around the edges that make sense to talk to an attorney and get things updated. For example, some of the state forms like a power of attorney or an advance directives form might make sense to get updated because you're no longer in the other state and now you're in Connecticut. So hopefully it's not a lot of work, but that is something that you should maybe give your attorney a call. In our office, we typically are, when we do an estate plan, there's sort of a one fee type of thing. And part of the reason for doing that, aside from knowing that you're going to have this fee and it's not going to change, is to hopefully motivate clients to feel free to pick up the phone and call if they have a question about a new family member or a new IRA account that they're opening or a new life insurance policy or buying a vacation home. I take those calls just about every day, and I'm happy to catch up with clients, find out about their family. And, usually a quick phone call can handle all of that and, with very little need for follow-up. So, I think that's how we try to tackle that motivation to get clients to stay in touch in our office. And, I always encourage clients to call. Okay, now we're going to get slightly technical. I'm not going to try to keep this at treetop level, but if you had to come up with the documents that you would want to plan as part of an estate plan, this is typically a married couple or even a single person would typically have this type of plan. So it would involve a will together with a revocable trust, and we'll talk about those two and the role they play together, a power of attorney, and advance directives, a HIPAA form, and then those beneficiary designation forms that typically cover things like retirement accounts and life insurance. So it's this whole idea of dovetailing your plan and making sure things don't battle each other. So we could work on all of the the basic estate planning documents and have a perfectly drafted plan that will do everything the client wants. And then a client passes away and we find out that their life insurance policy that they bought in 1982 when they first got out of school named mom as the beneficiary, and it never named spouse and kids. And so there's that coordinating and making sure that we have everything covered. And that's a really important part of it. And for some clients, that could be, a tricky part of the plan to make sure that everything works well together. I also mentioned jointly owned assets. They may or may not work well with a basic estate plan. So part of that process is to kind of take a look at what a client has, what the mix of assets are, and how they're titled, whether they're individual, joint, or they have a payable on death designation, and just working through it as a group, as a team, to make sure that everything meets your goals. And so keeping this in mind, maybe we take a little deeper dive at the first two parts of this. So many times a client might think, all I need is a will. And they're correct. Really, all you do need is a will, because a will can take care of what you have when you pass away, and it'll name an executor and it'll dispose of your assets. And it can even have trusts for your children or your spouse built into it. And it's not incorrect. It's very common. And a lot of people might have a will and do fine with their whole estate process. In our office, we tend to be fans of coupling a will with a revocable living trust. So the two of those things together, we think work better than just having a will. And the reasons are that a will only speaks at death, meaning, the years before you die or the day before you die, there's nothing you can do with a will except get it ready. So it can't take care of you. It can't take care of your family. It's just that one document that disposes of stuff in your name when you pass away. It's a public document, so it does get filed with the probate court. And so, sometimes clients might say, under no circumstances shall any money at any time ever go to Johnny. And I mean it. And if you have that and you put it in your will, not only will Johnny be able to see that, but all of his family and all of your neighbors. And so it's a public document, and you might not want to put the most confidential stuff in there. Also, if there's a trust that you have that is continuing on after your death for a family member, generally speaking, if it's done under a will, that trust stays subject to the probate court supervision. You have to file accountings, and you go to the court every few years and you have it reviewed, which is not bad by itself, but maybe if there's a way around that doesn't require you to file that information with the court, maybe you'd want to do that. And so that's where revocable trust comes in to save the day. So it has a lot of benefits, I think, over just relying on a will. The first being that it's effective and able to be used the day that you sign it. So you could sign a trust today, and then you can go to your bank or your brokerage house and move an account out of your individual name and into your trust. And then you'll have yourself probably as a trustee to start, but if you got sick, there could be another person behind you as trustee, and then they'll have access to the same money. And it'll make things easier to take care of you if you can't take care of yourself later on in life. So that's really a great benefit that I feel is something that needs to be covered for clients. Like if you get sick and need help, I don't want to have you go to the probate court and have a conservatorship started and all that reporting that goes with it. A revocable trust, even if you leave it empty for years, you know that it's there if you need it, and you can put assets into it at any time and take care of yourself. So I like that. Also, it's a private document. It doesn't get filed with the court. It's not, and no one can see what's in it. This continuity of managing assets idea is very beneficial for people. So I mentioned you could put things in this trust while you're alive. And then if you pass away, you have a backup trustee available to still get access to these assets. And so you don't have to wait for the will to go through the probate court process. You don't have to wait for the will in order to pay the funeral director. So it's really nice to have that continuity of the assets. And also, it's not subject to the court supervision. I mentioned that before, but it's standing by to collect everything that has your name on it when you pass away in your will. So I mentioned before that you had this combination of a will and a trust. So let's say you left your trust empty for your whole life because you never needed help with managing assets. You just left it empty. And then you pass away and all of your accounts have your name on it. So what's going to happen is your will is still standing by like a catcher's mitt to catch those assets. And it's going to direct them to go over to the trust. So whether you fund your trust while you're alive or whether you fund your trust at death, it's going to get all of your assets, and then it's going to be disposed of. Your assets will be disposed of under the terms of the trust. So it's kind of like I drew these two boxes almost in proportion to the importance. It's still important to have a will, but the revocable trust will really be the star of the show, and it will be the document that I said takes care of you during your lifetime, and then takes care of your family when you pass away. And it can provide for the spouse, and it can provide for children later on. One last note, the revocable trust document by itself doesn't really do much from a estate tax planning or income tax planning, but the articles inside it can save money for the family down the road. So all of the tax planning you do in a trust could be done in a will, but we prefer to do it in a trust because of these other benefits that I mentioned. So when a client says to me, should I fund a trust completely and avoid the will, or should I partially fund the trust, or should I not fund it at all? I'm pretty neutral to that, with the exception of if you own out-of-state real estate, it might be beneficial to title that in your trust because you don't have to go to that local jurisdiction for probate. And if you're elderly or have a health issue, I would put maybe at least one account into the trust so that somebody's available to take care of you financially. But it's the type of thing that's different for every client. And I sort of have a dialogue, and we go back and forth, and we can usually come up with what makes the most sense for that client in that situation. The second document here of an estate plan is a power of attorney, which is it's a small document, but it's a dangerous document. So be careful with it. It's generally speaking, by signing a power of attorney, you're giving the person you name, your attorney, in fact, the authority to have access to your accounts and your assets during your lifetime. presumably to take care of you, or presumably to move assets over to your trust agreement if you become sick and didn't get around to doing it before you got sick. So it's a very important document. I think it's almost essential. But in the wrong hands, with the wrong person in charge, a lot of damage could be done. So we try to be very careful with them in our office. One thing we do is we hold on to the originals for clients, and I sort of act as a gatekeeper. So if I get a call from, son Billy that says, I want mom's power of attorney, I'll call the client and I'll say, your son asked for this, is it okay? Or I'll find out if mom is in a situation where it might be appropriate because of health or other reasons. So that's one thing. There's a tension with these powers of attorney that's kind of hard to reconcile, in all honesty. We want to kind of keep them focused and small so they're not abused. But if they are very tailored, the chance of them getting accepted by an institution is greatly reduced. From a liability standpoint, I can just tell you based on experience that banks would really, really rather you never use a power of attorney for one of your accounts there, because they're just completely worried that it's going to be a lawsuit in the future, and they have anxiety over it. So they'll try to figure out, in many cases, a reason not to accept it. And if you have a really tailored power of attorney, that says only use it for this particular type of account, they might claim that it's not effective in that situation, in that institution. So we typically make these go the other way. We make them very broad, and we make them durable, which means it still works even if you get sick. We make them effective immediately the day you sign them. We don't make them spring to life when you get sick, because that would probably require a court hearing. We don't want to do that. We're going to need them quickly. So really should be very careful about who you pick and just the use in general. But like I said, I feel it's an essential part of an estate plan. So, in the right hands, it's very important to have. One thing I've noticed that the clients don't necessarily know, or families don't know, is that a power of attorney doesn't work when the person who gives it passes away. So, I could meet with clients a month after somebody has passed away, and they'll say, oh, I've still been paying mom's bills because I'm using the power of attorney account. Technically it's not correct. It happens, but it's really not correct. So just want to be careful. There's potential liability if you know of somebody in that situation. The next things here are, at least on the left side, form documents, but they still nonetheless remain very important. And then on the right side are those beneficiary forms we talked about. But let's start with the left side. Advance directives, I think one of the most important things you can consider and make sure you get in place and put a lot of thought into how you fill it out. So this is sometimes called a living will in some states, or it's called a medical power of attorney in some states. Connecticut came up with this Advance Directives terminology. So it really has two parts to it. It's appointing somebody to make healthcare decisions for you, including end-of-life decisions, if you can't do so yourself. So that's important to stress, that by just doing this document doesn't mean you've delegated authority for the next day. It only comes into action if you can't make your own decision. So that's very important to note, but it's very important to have, because this is the legal way that a hospital would be able to have decisions made for you if you can't do them yourself. So this, aside from just general medical decisions, this also includes end-of-life decisions, and especially artificial respiration, artificial nutrition and all of the parts of those end-of-life decisions that you might not want to think about but need to focus on. But keep in mind that those decisions or your wishes with those decisions do not come into play until you reach that point of a terminal illness with no likelihood of recovery or permanently unconscious with no chance of recovery. So they really are meant to avoid those terrible, terrible situations that you hear in the news of somebody on a respirator for a year and the family can't agree on what to do. So, you know, put the time into thinking about who you're going to pick. It's the type of job that you really just want one person at a time. You don't want a committee, but you should have a backup person. The HIPAA form is also important if we ever need to get a letter from your doctor on your ability to act as a trustee. And so we do have clients sign that just in case. I just want to talk about taxes for a second. I don't want to dwell on it too much, but I feel like it's an important part of any one of these discussions. The law is extraordinarily generous right now with before you're hit with an estate tax. So federally, it's $11.7 million. Now that might, and it will scale back in a few years. The law might change and scale it back. When I started practicing, I'm embarrassed to admit the free amount was $600,000. So it's made a lot of progress, but while it looks like a giant number, you still want to plan for possibly having assets over that because of the possibility of the exemption going down. And also you can see Connecticut is a little bit less generous, surprise, surprise. So it's not quite as beneficial to pass away in Connecticut as it would be in a state like Florida where there's no estate tax. But Connecticut is increasing its exemption every year, and it's trying to move toward a more beneficial situation to not lose so many residents moving to other states. So this is the what I call I love you will estate plan, when you just have a simple will that leaves everything to a spouse, and then at the second death, everything to kids. And maybe the shortest version I've ever seen has been a 2-page document that does this. And hats off to the person who drafted it. I would not be able to do it in so few words, but like I said in the beginning, this could be perfectly fine, but generally speaking, you'd like to at least think a little bit about taxes and planning if there's a possibility. And as an attorney drafting for clients, I always have to think about that. So this doesn't work for many of my clients. And the reason is not what happens at the first death. So if you leave an estate entirely to your spouse, 100%, just outright, there is no estate tax because there is an unlimited marital deduction from estate tax. So 100%, no tax. The problem with that is when the survivor dies, and if you don't do any other planning, not only do you have to include the survivor's estate for tax purposes, but you also have to include anything from the first spouse because there was no planning. So instead of having an exemption available to shelter the first spouse's estate and an exemption available to shelter the second spouse's estate, this plan actually wasted the first spouse's exemption. And you really have to hope that the survivor has enough of exemption left to shelter the estate from taxes. So that's why there's a question mark on whether or not there's estate taxes. And we really don't want to leave it up to a question mark if we can take steps to minimize it. You can never eliminate taxes completely, but you can take steps to minimize them. So this is the new and improved, better than before estate plan. And I have this under a revocable trust because that's how we normally do it. And I mentioned before that the trust has the added benefit of caring for the couple or the individual during life, which you can't do with a will. So I like to think of a trust as a 3-chapter book. Chapter 1 take care of the couple for their life. At the first spouse's death, Chapter 2, provide for the survivor. And at the second spouse's death, provide for the family, the children. And then in this step 2, we have a little detour here of a disclaimer trust. And that's just meant as a vessel or a vehicle to hold the first spouse's exempt from estate tax property if the survivor decides it makes sense to do so. So let's say husband dies with a large estate, leaves everything to spouse. Spouse, with our advice, could disclaim up to the 7 million or 11 million exemptions, hold that money in a disclaimer trust that the survivor can still benefit from, use the money, survivor can be in charge of the money, whatever's needed. But the big benefit here is when the survivor dies later on, whatever is in that trust, including whatever it grew to during the survivor's life, gets to go down to the family with no estate tax. So that's great. And then the survivor's estate is not going to cover everything in this example. It's only going to have what was in the survivor's name. So hopefully it'll be small enough that there's no estate tax. So instead of just having one exemption available, this plan contemplates using 2 exemptions, which is really not that much additional work, but really a tremendous, tremendous potential benefit for the family, while still allowing the survivor to have access to the money and stay in charge of it. So not much that you're giving up, and you have a great potential. And then also, if it's not needed, you can just avoid this trust. You can just make it an I love you plan. You can just say, I'm the survivor, I'm going to keep it, I'm going to give it to my kids. It's just nice to have that option in the plan, and it's worth the effort to put it into it. So a lot of times clients ask about, does it make sense to have trust for my kids or no trust? And trust for my business. So I'm going to have a bias of being in favor of trust versus no, but in all reality, there are some benefits here, and I think they outweigh the simplicity and benefits of outright distribution. So the main reason to have a trust is you don't want a 4-year-old getting a large inheritance without anyone controlling it. So obviously for young children, even not so young children, it might make sense to have a trust. For creditor protection, it's definitely better to have money in trust versus in a person's individual account. And when I use the word creditor, it could be a spouse, it could be a child's spouse that might be easier to get at in a divorce if it's outright in the child's name versus being in a trust. And so that's a strong reason for a trust. And then there's always some sort of tax savings. I mentioned just before about the disclaimer trust. You can't do that unless you use a trust. So there might be a tax purpose for doing it. But I think the first 2 are the main reasons. And on the negative side, obviously, trust assets have to be segregated. They have to be held in separate accounts. There are tax returns and some ongoing maintenance. But, for many, many client situations, there's a trust part of it, a component to it, and it makes sense. The best part of this outright distribution to a person is that it's simple. You don't need to do much except hand over the money at the end of the probate. But we have, I could probably spend another hour talking about situations where money has been spent unwisely and foolishly and gotten into the wrong hands at the wrong time. Also, parents like to try to control the funds, even maybe for another generation. And so make sure that if there is an issue with the child's spending habits or something, there's some money left for grandchildren. And then again, money can be reached by creditors. So it's a balancing act. There's no absolute answer for anybody, but I really do like to draft trusts because I think they offer a lot of benefits. And the absolute key word when it comes to drafting is the word flexible. we are not smart enough to know every situation that every beneficiary is going to need for the next X years. So we go out of our way to make these trusts very flexible and make sure that they're not tied into a corner where you can't get out if it doesn't make sense to continue it. So if you have a flexible trust and you have the right people in charge of your trust, that's the other part of a successful plan, picking the right fiduciaries, you'll be very well served. And so this, I just want to end with this part. I can't stress enough the importance of making sure that you pick appropriate people to carry out your plan, because you'll always have help of a lawyer and an accountant and a financial advisor, but you still need the quarterback and the person that you trust to do what you would do if you weren't here and needed to have your estate taken care of. So the executor, we've mentioned, it's the most administrative job of the bunch. It's the person that probates your will, values your assets, files tax returns, and then hands out the assets to the final recipient. So it's about a year to a year and a few months long process. And it's nice to pick somebody that's organized and you trust being in charge of all of these different people. Guardian, the guardian is the taking care of you, the substitute parent for your minor children until they're 18. The guardian is the person that puts them on the bus and feeds them and buys clothes. And obviously, you don't want to leave that up to some other person to decide. So you can't do more important decision making than pick the right guardian for your minor children. Trustee is holding money for the trust, in charge of the investing, in charge of the distributions, kind of like in some cases, the parent with the checkbook when you're talking about trust for kids. It's a longer term job. It takes more time. You have to worry about investing. Obviously, with the help of an advisor, you have to worry about distribution decisions. And so, you want to be very careful of picking a trustee in terms of capability, desire to do it, and also age becomes a factor because these trusts can go on for decades. So not that that should be the primary factor, but you might want to consider, for example, having a backup trustee in case you're worried about the age of the first trustee. You might want to have co-trustees. You might have a family member who knows these kids' needs, but might not be so great with investing or managing money. And then you might have a friend or an advisor or somebody else that you trust that you think would really be on top of that part of it, but might not know what the kids need on a day-to-day basis. So you might want to do a combination of the two, like a check and balance, a good cop, bad cop type of thing. So that could make sense. Also, we talked a bit about the attorney in fact. Typically, clients will choose the person they name as a backup trustee in their document. They'll typically name as their attorney in fact because they kind of have similar roles. One is during life and one is typically at death, but it doesn't have to be, but that's a normal decision clients make. And then again, with the healthcare representative, you want to have a backup named, certainly, and you don't want it to be a committee decision at all. You would really like to have it be one person at a time. I'm sure your representative will speak with family members, but for the sake of everybody, having one person in charge makes the most sense. And we really encourage clients to do that. So in a very, very quick, broad manner, I hope this gave a decent overview of the process and kind of give you some things to think about and hopefully motivate you to wherever stages you are in this process, maybe motivate you to take some steps to kind of get it either cleaned up a bit or pushed to the finish line or maybe completely reworked.
Thank you so much, Mark. I've got a lot to think about. I'm sure everyone else does too. I really appreciate the time that you took to go through everything. I feel like it's a little less intimidating of a process because I'm new at this, and this is a goal of mine to get accomplished this year.
Yeah, great, yeah.
Okay, we have a question. Let's see. Someone wants to know, when one lives in two states, where is the trust written?
Yeah, that's an excellent question. So you can have a residence in two states, but you're only supposed to technically have a domicile in one. And so that's the word domicile is the place you call home and intend to return to. So it's not it's a fact and circumstance test. Where do you see your family? Where do you spend holidays? Where do you call home? Where are your doctors? Where do you vote? That's typically the state that's going to be your domicile state, and that's the state that's going to claim, jurisdiction over you when you pass away, and your will be admitted primarily in that state. So it's certainly possible to have two homes, but the domicile home will be where things are probated and where the trusts are drafted, and then you will do an ancillary probate, which is just a sort of a mini probate in that other state if it's necessary to do that.
Thank you. I never even thought of that question. If anyone has any questions for Mark, please put them in the Q&A or the chat and he can get to them. I see that someone has their hand raised. I'm unable to hear you speak, so you'll have to put them in the Q&A.
I can't even see.
Thank you. I had a question. I was talking to someone about just, objects in your house that you want to, will to loved ones. And, what happens when people start arguing of, why are you getting it and whatnot. And someone said that in their will, they put like a little note with almost like a memory, like, okay, I'm giving this mixing bowl to Shanna because we made cookies one year, da da da.
Yes.
So is that something you recommend to avoid sibling?
I am so in favor of any steps that could be taken to avoid disagreements over, we call it tangible personal property, the stuff you own that you can touch. And it's remarkable how much effort and time and angst is spent dividing tangible property that most of the time it's just sentimental value. But you can split a CD into two or a bank account into two, but you can't split a sofa or a wedding ring. So it is a struggle, and I've had the full experience of clients doing it all on their own and clients fighting over absolutely every piece. So there's two ways to tackle it. One is putting all of your wishes inside your will. This ring goes to this person. These golf clubs go to this person. And that's very formal, and that's the most greatest chance of being respected, is to have it spelled out in a will. The problem is people get different things over time, and so it's not practical to put everything like that in the will, and it's also more private than you would want to see everything in the will. So we encourage clients to leave behind a memo. And the beauty of the memo is that it can be done relatively informally. You can type up a memo, dear executors, these are my wishes with regard to my tangible property. And you can put it down, sign it, date it, keep it with your will, and also change it over time without having to come in and redo your documents. And the downside is, in Connecticut at least, it's not something that can be accepted automatically by a court. So it's meant to be guidance in Connecticut. If it's to be respected and enforced, it would have to be in the will. But I think in the vast majority of the plans we work on, clients will choose to do the memo approach, and it's very, very helpful because they can give their reasoning, just like you said, and they might give a bunch of things to one person with the hope that that person will hand it out as appropriate to other people. And it's the best way to do it, because you can really get bogged down in the details of it if you don't do planning for it.
Thank you. Okay, we have a few more questions that came in.
Sure.
Is Is the disclaimer trust the same as a traditional AB trust? If not, how are they different?
They're very similar. You could have maybe 8 names to that type of trust. The idea is the disclaimer trust or the AB trust or the bypass trust or the family trust. They're all generally trying to do the same thing: utilize and not waste the first spouse's exemption from estate tax. So it's really, that's the goal. The trust accomplishes that. The difference between them is like just taking the AB approach or bypass approach to the disclaimer. That's an automatic splitting of assets when somebody dies. It usually an AB type of plan says, when I die, take the exempt amount and put it in an A trust, and then give everything else to the spouse, either outright or in trust in the B part. The beauty of the disclaimer approach is it allows the survivor to assess the situation at the time and decide when the first spouse passes, knowing what the law is then, knowing what the assets are, and knowing what the wife or the husband is thinking, to decide how much and which assets to fund that disclaimer trust with. So it's a more flexible wait and see type of plan. So when I started practicing, we were primarily doing AB trust because it's an autopilot plan. But with the changes in the law, we've migrated over in most cases to this disclaimer approach because we really like that flexibility to leave it up to the survivor to assess and decide what to put in there. So they're close, but there are important differences between them.
Thank you. If a will is drafted, or if a will that was drafted in England, is it valid here? And what are the implications if half of the couple is a green card holder and not a citizen?
I have never come across of a will outside the U.S. that's been probated here. So it's not, I don't know if it's ever happened. I just haven't seen it, and I wouldn't want to rely on that at all. They are really different laws from Europe and England to the U.S. So I would not rely on that at all. I would get a U.S. will. But there's something important to think about in that context before I jump to the non-citizen issue. Clients very often have assets here and they have assets outside of the US, whether in Canada or in Europe or elsewhere. And generally speaking, you need to do an estate plan that disposes of your US assets and an estate plan that disposes of your non-US assets. And you have to make sure they don't fight each other, because the first line of a will is, I hereby revoke all other wills done by me at any time prior to today. You need to make sure that that doesn't revoke your UK will or your US will if you're doing it in the UK. So there needs to be coordination, but the short answer is you should have a set of documents that dispose of US assets and a set that dispose of non-US assets. If you're not a citizen and you're married, there are some additional planning obstacles because there is not an unlimited marital deduction when you leave things to a non-citizen spouse. The worry is that spouse is going to leave the country and take all of this otherwise taxable money away and out of the system. So there is something called a qualified domestic trust, or a QDOT, that we typically incorporate into estate plans when a non-citizen spouse is involved. So it's a little bit trickier, but certainly not out of the ordinary.
Okay, one that I'm curious about. How effective is it to write a phrase that says, if you dispute this will or trust, you will automatically be deleted from any benefit except for $1?
Yeah, an inter aram clause, a no contest clause. I guess the best way to say it is they're frowned upon, but we use them in particular circumstances because you have the right to say that. So it's a very fluid back and forth discussion that we have with clients when we talk about it. And there are definitely situations where I will include that in a way to try to prevent somebody from disputing what's in a will. There's other times when there might be a feeling that you could do more harm than good by putting it in. You might be egging on the client. I've got nothing to lose. I'm going to fight, or the beneficiary, their child. So used judiciously, it can have its place. We don't use them routinely. And I think if there is a bias when it's put before a judge, I would think that generally the public policy is to try to figure out a way around it, because it can seem very harsh.
I just want to know, it is 8:02. We have a lot of questions. So I'm just going to pick a few. And Mark, would it be okay if I sent you the questions we don't get to?
Oh, sure. Absolutely.
Okay,
I'm happy to answer anything. Sure.
Wonderful. Let's see here. Can power of attorney be made effective only when someone becomes incapacitated or can no longer make decisions?
It absolutely can. That's called a springing power of attorney. So you sign it today, it doesn't spring to life until you're incapacitated. The issue with that is convincing an institution that the time has come to use it. So if I went to a bank with a springing power of attorney, they're not going to take my word for it. So I think it would probably require some form of a judicial determination, or at a minimum, some type of letter from a doctor or qualified healthcare provider to indicate that. So I think chances are a typical bank would really try not to make that work.
I'm going to ask one more question just because it's from someone who's anonymous and I wouldn't be able to get a hold of them after. How does the survivor get their money out of the trust to use for daily, monthly, or yearly living?
It's usually very flexible. So most times in the plans that we do, the survivor is the trustee, who's the person in charge of the account. So it won't be any different from your normal life use of accounts. It's just going to have the word trust on it. And so, if you need to pay bills during the month, you could do two things. You could pay every bill out of the trust account, or you could take a periodic distribution out of the trust into your personal account, and that would work just fine too. You want to be pragmatic about it, and a lot of times we're doing trusts for tax planning purposes, so we don't want to make it burdensome or more difficult than it otherwise needs to be. So in the vast majority of cases, there's a rhythm to it, and it works out without a problem.
I have one more anonymous question.
Sure.
Someone wants to know, they said their mother-in-law named all 3 adult children as power of attorney. Good idea or a bad idea?
Depends. Typical lawyer answer. There's 2 ways it could be done. You can have a joint power of attorney where everybody must act together. So that would just say the word jointly after it. Child A, B, and C to act jointly. The problem with that is just the mechanics of getting 3 signatures on everything. There might be a need to do something quickly, and getting 3 signatures could be difficult. Or if there's disagreement, 2 versus 1, and it's a very reasonable thing, you now have a dispute that you can only really resolve by a court. So there's protection in having 3, but there's also risk. And so I would generally say to act jointly is not a great idea. To act severally, which means you can act independent of each other, has some benefits, namely that you have 3 people that can help if needed. And maybe that makes sense from a convenience standpoint. The negative of that is you have 3 people that could potentially abuse it, or one could use it, the other 2 could say, hey, wait a minute, I didn't like that idea. Why'd you do that? So I don't want to make generalizations, but I try, when there's going to desire for a joint, I try to generally encourage naming 2, maybe as the magic number, not 3. And then there's always an issue if you have multiple children and you're putting one child in charge of all of these roles. There can be a little bit of disharmony within the family, like, oh, I guess dad loves you more because you're named executor. And the real joke of it is whoever's named executor is the one that got the short straw, because you have all this responsibility and all this things that can go wrong, and you don't get any extra benefit from it generally. So it's not necessarily the winner, but those are the things that clients try to balance out and weigh. And, sometimes it causes issues, but hopefully it works out because there's always appropriate people within the family that are best suited for their particular jobs.
Yeah, I feel like that's going to be my job. I'm the organized one. Thank you again, Mark. If your question has not been answered, I will get those to Mark, and I'll get those passed on back to you. Thank you again. This was wonderful, very informative, and you'll be getting a call from me, so I can set up my
My
role.
pleasure. Thanks so much, Amanda. It's been a pleasure. And thanks everyone for spending the time. I really appreciate it. And I hope it was helpful, and you take care.
Thank you again. I really appreciate it. Have a good night, everyone.